In this video, we're going to address what the patent appeal process looks like, what are the different types of patent applications, and what is considered prior art. First, you could have three scenarios that happen during the patent prosecution phase. First, you persuade the examiner regarding every objection and rejection. The application is going to be allowed. Second scenario, you don't persuade him regarding everything and you don't want to appeal, so you could abandon the application, or it could become a different type of application, which we'll see in a few minutes. Or the third scenario, you don't persuade the examiner regarding every objection and rejection and you want to appeal the process. So the patent appeal process looks like the following. First, you'll receive a final rejection. You're going to file a notice of appeal and you're going to pay the fee. Next, you're going to present the arguments to the patent trial and appeal board. The examiner is going to file an answer. The applicant will then file a reply brief, and then they'll request an oral hearing. And at any time, the applicant can withdraw, but if they would withdraw the application, that's going to result in an abandonment of the patent application. Next, the appeal board can decide whether or not they want to affirm or reject the patent for any reason. And if they reject it, then you're going to have to either submit an amendment to the patent, or you could ask for a reconsideration. If you still don't like the judgment, then you could appeal in the U.S. District Court in Virginia or the Court of Appeals. An alternate scenario that could happen is you receive a final rejection and you abandon this application, and instead you file a continuation application, which will allow you to start over without the final rejection limitations. So this is going to be a different route in order to open up the patent prosecution process. However, you're normally going to not be able to add any new claims or arguments, and you're definitely not going to be able to add any new matter. To create a continuation or divisional application, you're going to need co-pendency with the parent application at the time of creation, and you're going to need at least one inventor in common. And you're going to benefit from the earlier filing date. Next, you could amend your patent application, which is any change to specifications, claims, drawings that are after or at the same time the application is filed. You can amend an amendment, but you're allowed to amend an amended part of the changed application. It's important to realize. And special rules are going to dictate where after a final rejection, whether or not you're going to allow amendments. Next, what is prior art? Prior art falls into 7 categories, whether it's a prior publication, prior patent, prior sale or offering for sale, prior use, prior knowledge, prior invention, or abandonment of an invention. Those are prior art. And if they have prior art, the patent is going to be said that it has anticipation and it's not going to be allowed to be obtained. And how do you define the word prior? Is you're going to look at the filing date. And now we use a global scale where it could be a prior publication. It doesn't have to be within the US to be considered prior art. There are 6 different types of patent applications. The first is a standard application, which is not related to any other application, and it's not a provisional application. Next is a continuation application, which is a co-pendency, and it's a branch off. And you could do this to file to restart the prosecution as opposed to appealing the process. Next, you could have a continuation in part application, which also has co-pendency, and this one adds new matter. It's the only type that adds new matter, but you're not able to file it under 1.53D. The fourth, you could have a substitute application, which is the same application by the same applicants, but there's no co-pendency, so you don't get the benefit of the earlier filing date. Next, you could have a divisional application, which is a distinct and independent invention. And you could have a provisional application, which you file to get the earlier date. You don't need to have any claims or any oaths. However, it auto-abandons after 1 year of filing. And lastly, you have the concept of the best mode, which is the inventor is presumed to make the invention that is the best mode that is known to him or her at the time of filing. I'm going to thank you guys very much, and I hope you all have a great day.